Calling the fourth case on our list this morning, SJC-12265, Beacon Residential Management LP v. Calum Pipkin.
Mr. Is it Emer or Emmer?
Emmer.
Emmer. All right, you may begin.
May it please the court, I'm David Emmer of Nutter, McLennan & Fish, representing Edna Lore Pipkin, the proposed intervener in this case. Ms. Pipkin urges the court to afford her the opportunity to protect her family from domestic violence without losing her home. Ms. Pipkin's two sons are 6 and 8 years old. Ms. Pipkin, her sons, and her husband lived for years in the apartment that is at issue in this eviction action. During that time, Ms. Pipkin's husband abused her. After multiple attempts to stop the abuse, which is common among domestic violence survivors, Ms. Pipkin obtained a 1-year abuse prevention order, forcing her husband to vacate the apartment and not to contact either her or her children. 12 days later, the landlord began the process to evict the family. To defend against that eviction, Ms. Pipkin sought to intervene.
Can I just ask you a quick question? Are you looking currently here now, are you looking to your client's intervention just on her children's behalf or on her own behalf as well?
We're looking on both her children's behalf and her own behalf.
Thank you.
Let me ask you, you're about to talk about the motion to intervene, and I just ask you as you answer that question, what's the judge's reach as far as factual findings relative to the motion to intervene?
The Rule 24A talks about a claim of interest in the subject matter or the property that is the subject of the action. So it has to be facts related to that property or subject matter. The case law states that it cannot go to the ultimate merits of the claim.
So the judge's fraud finding would be irrelevant in this case?
That's correct, Justice Hines. The fraud finding should not have been reached at all for at least two reasons. The first is that the landlord's procedures were not followed. The Department of Housing and Urban Development has procedures that landlords are required to follow before evicting a family. And this court in Rivas v. Chelsea Housing Authority stated that those administering programs for the benefit of low-income people, the landlords need to follow those procedures. And the second reason that the fraud was entirely irrelevant was, as to Justice Lowy's question, is that finding fraud is a fact-intensive inquiry that goes to the merits of the intervention. And it's especially true here, where the key question in this case is the reason that Ms. Pipkin is not on the lease. The landlord's theory is fraud, but Ms. Pipkin's claim is that it was her husband's abuse that caused her to not be on the lease. And the landlord reinforced that abuse because when she went to the landlord's employee, she did the very hard thing of telling the landlord's employee about the situation in her household. And
well, how do we get past the judge's factual finding that the reason she wasn't on the lease was because of fraud and not because of anything else?
We get past the factual finding because that finding goes to the ultimate merits of the case.
But it's the reason why she wasn't on the lease.
It's the reason it was in the judge's intervention inquiry. It's the reason that she was not on the lease. But the ultimate merits go to an issue that should be decided at trial.
So this is my question in this regard. When she goes to the office and she wants the application and is trying to get on the lease, and your position is that she's not given the application, when the judge makes findings as to that point relative to the motion to intervene, is that a permissible finding for him to make or not?
Which finding in particular, Justice Lawley?
That she didn't go there and ask for an application. That didn't happen. And that is part of what leads the judge to say, this is all about a fraud that had been perpetrated for a while, that she'd moved in, that she was never part of this lease, and that it was a conscious decision to try and continue this Section 8 housing. And what I'm trying to figure out, and I think you're trying to tell me, so that's my specific question, is there a conflation of the merits of the case when the judge says she can't intervene because she engaged in fraud? Or is it that the judge is right in that finding, she can't intervene because of fraud, and that that's a factual finding necessary on a motion to intervene? Do you understand the question?
Yes, I believe I do. That fraud is just wholly irrelevant to the intervention inquiry. And on a factual point in the case, it is important to point out that at page 199 of the record, it was the landlord admitted not giving her the application and not following its normal procedures. That's not even my client's claim. So I think my client went beyond in being able to meet the intervention inquiry. But
Could I just, along those same lines, could you just maybe put it in the positive? What was it the judge could consider on the motion to intervene? What facts were relevant to that?
So on the issue of the children,
Well, there's the children and the mother. The mother wants to intervene on her own behalf, you said, in answer to Justice Budd.
Yes.
As well as on behalf of the children. So why don't you answer those questions independently?
I'll start with the mother to your Honor's question. So this is laid out in our brief. But there are three facts that gave Ms. Pipkin the interest in this apartment. The one was the application, and then number two was that she lived there. And then the second is the abuse prevention order. Sorry, the third is the abuse prevention order. So an abuse prevention order is not dispositive over whether the mother.
That ground alone, just the fact of the abuse prevention order, is that alone enough to give her the right to intervene?
My position is that all three are enough, at least to give her the.
Or together?
Together, at least, they're enough for her to intervene.
So we're trying to sort this out. You are saying that where somebody says, I live here, the landlord is seeking to evict my husband from this unit. I live here with my children. I am an applicant and my children are affiliated individuals, and I claim that if the eviction goes through, it will evict me, and therefore I have an interest to the property, that she's entitled to intervene, and that the issues of whether or not she is truly an applicant and the issues of whether or not she had committed fraud are matters to be preserved or left for trial. Is that your claim?
That I don't think we need to go that far in this case, because the judge found those things as facts.
But that's the issue. The question is, do we evaluate whether the judge is clearly erroneous in those findings, or do we say, no, that was the wrong standard? The judge can accept as true the allegations in determining whether you can intervene, and the issue of making factual findings doesn't happen until after the intervention and you go to trial.
So the current standard in guardianship of VVG at 474 Mass, it's at page 320, talks about being able to find facts, and also about it being a question of law. And so under the current standard, there is some ability of the judge at the intervention inquiry to determine facts related to the interest in the property.
And what facts do you say were relevant that the judge needed to find?
To intervene.
Yes.
The fact was that an abuse prevention order judge thought that this was the safest way for the family to live. So that's undisputed. It's in the abuse prevention order. The fact that she lived there for many years. If she had only been there for a week, that may not have been enough. But given that she's lived there with her children for many years, that's sufficient. And then the landlord's knowledge, I think, is a trickier issue. But here, in page 171, the judge found that the landlord even knew that she was there. So I think that definitely the first two, and then the third possibly is what should get you over the bar under the guardianship of BVG standard.
What did this restraining order say specifically about her residency? I assume it said stay away from her, and she lives at this particular address, correct?
Yes, it did. It said that the plaintiff's residency was at the apartment at issue, and it ordered the only adult named tenant on the lease to leave. And that speaks to, again, back to Justice Budd's question about the children's interests. So the children's interest in this apartment is very clear, because the children were lawful occupants of the apartment, and their interests need to be represented in some way. The father lost custody of the children through the abuse prevention order. There was no one else present other than Ms. Pipkin to represent the children's interest.
What gives the children a legal interest in the apartment?
It's the fact that this is subsidized housing, and so the children are not only losing an apartment that they can go to another market rent apartment. The landlord needs to
I get that, but what is there a statute? Is there what is it that gives them the children the right who aren't parties to the lease? The
VAWA, the Federal Violence Against Women Act. After the appeals court decision was issued in this case, the court said that a tenant includes anyone on the lease. It includes any member of the assisted family.
And were the children on the lease?
The children are on the lease. The only one in the record is at page A91, and it shows that the older son was on the lease. The younger one hadn't been born yet.
What do we do with the judge's finding that she was off the lease in 2009, she's trying to get back on the lease, and she's also the sole custodian of the children who live in the apartment? What do we do with the judge's finding that this whole effort had nothing to do with domestic violence? That was a finding he made. Is that a permissible finding, or is that conflating the merits again?
I think first it goes to conflating the merits, but the judge even acknowledged that she was a domestic violence victim, because that was found by virtue of the abuse prevention order. And if the court thinks that that's something that has to be established in an intervention inquiry, then we would want to remand to have the opportunity to establish that. And on the domestic violence point, I just strongly urge the court to not close its eyes to the larger context here. As Casa Mirna is the largest provider of domestic violence services in the Commonwealth, and their brief, along with Jane Doe, explains that the moment a victim is trying to flee her abuser is one of the most dangerous times for a victim. And that is precisely the situation here. The landlord began the eviction process 12 days after Ms. Pipkin obtained an abuse prevention order. The brief also explains the strong connection between homelessness and domestic violence. And last year, for example, 74% of domestic violence survivors calling Casa Mirna's domestic violence hotline were told there's no available shelter.
Can you explain to me how the VAWA process would work? So say we agree with you in that the two minor children have an interest in this property because they were on the lease or pursuant to VAWA. The husband can't go near the household. The children are there with the mom. Can the landlord not evict that family? And if not, for how long?
I don't think we got there yet, because the fraud.
Talk about an intervention, right, and the ability to join the suit, but how does that work under VAWA?
Under VAWA, the children would have the opportunity to remain in the tenancy if a parent leaves, and VAWA, I think that VAWA addresses that in saying in the statute that a child cannot be evicted, a tenant cannot be evicted of children or tenants as a direct result of domestic violence. So the children would be permitted to stay if they win the eviction case at trial, and then the person who was given the custodial custody of the children would be able to live there with them.
Okay, thank you.
And does it matter if there is a finding that the custodial parent was somebody who had defrauded the landlord by living there without being included on the lease?
If at trial it were proven, and after resort to the procedures, then yes, there could be a situation where that parent would not be permissible to be there with the children.
What do you do if the children have rights, but the mother doesn't? The children can't live there alone.
The children could try to find another caretaker. The other another alternative could be that, and the case Arsenault v. Chicopee Housing Authority talks about the father's care embracing the child, and so I am aware, from doing some research, talking to legal advocates in this case, one option can be to treat the mother as a caretaker, so that the mother would not have rights herself to the apartment. But if the court ultimately found that she wasn't entitled, but the children could stay there based on their own rights. But I again urge the court that this is at the intervention inquiry.
Because notwithstanding the fraud finding under VAWA, as for the mother, she'd have to be an applicant, correct, or a leaseholder?
She would, to raise the claim under VAWA, she's raising it as an applicant.
Right.
Yes.
And I know you argue what applicant means, and you disagree what that means, but what you're saying is it doesn't really matter because the children under VAWA have a property interest.
Yes, that's right. It could be based only on the children.
Sufficient to at least intervene.
Yes, and I emphasize the court. It's not just not me disagreeing. It's the holding of this court in the Bridgewater decision, saying that a reasonable accommodation, and someone requesting a reasonable accommodation doesn't need to use the magic words. And I really encourage the court to look broadly at this issue and understand there is a very strong analogy between disability discrimination and the needs of domestic violence survivors. And it's not based only on policy grounds. It's based on the explicit congressional findings of Congress. Congressional finding number 12 in the Violence Against Women Act states that housing administrators need to meet the unique needs of families, so that's the children and the mother, experiencing domestic violence. And so it's very critical. This case is obviously of crucial importance to my client, but it's of crucial importance to survivors across the Commonwealth who face situations just like this.
Ask you, are the Pipkin children and mother still in that house?
Yes, they still live there in that house. Okay. They've been paying use and occupancy for a long time now. Yes.
Okay.
Okay, thank you.
Thank you.
Ms. Quijano, good morning.
Good morning. If it please the justices, I am Therese Quijano from Turk and Quijano, and I represent the appellee Beacon Residential Management Limited Partnership. I would like to start with saying that Beacon Residential Management fully supports victims of domestic violence and is at the very forefront of providing protections on a daily basis to victims of domestic violence.
I mean, not to state the obvious, but there could be lots of victims of domestic violence who are on that waiting list.
There are many, exactly. And Beacon is 100% committed to protecting the rights of anybody who is a victim of domestic violence, men, women, anyone who qualify under this statute. And that's first and foremost. The second thing is, unfortunately, this case has nothing to do with domestic violence.
But isn't that something best left for a jury to decide, or a fact finder? I mean,
Whether or not an intervention.
Well, no. I mean, I know you're saying that there's issues that fraud and all of those things, but isn't that something that would best be left to a trial?
Well, there's two issues with the fraud. Fraud first would be at the underlying eviction case, certainly, but fraud also needs to be looked at in relation to whether or not Mrs. Pipkin or Mrs. Pipkin on behalf of her children have the right to intervene into the summary process action. We need to look at fraud because fraud is what she committed, and that's how we find that she doesn't qualify under VAWA.
Yeah, but you have this 14 days, right, after she gets the 209A order when the eviction proceedings get started. I mean, why isn't there sort of a presumptive connection between the 209A order and the ability to intervene just on that basis alone?
There is somewhat of a connection, but the totality, if you look at the facts of this actual case, is that Ms. Pipkin was creating a whole bunch of disturbances on the property at the time that she then got this restraining order. They all happened within this beginning period of May.
How do we know that?
Excuse me?
How do we know she created the disturbances?
Well, there are reports, those were our allegations in the notice terminating tenancy, that she was with different individuals, men in cars in the parking lot, and she was threatening security guards on the property. That was the grounds for eviction, in addition to the fact that she was an unauthorized occupant in that she wasn't allowed to be living there, and we got this abuse prevention order that stated that she had, in fact, been living there since 2009.
But that was known to the
It was not.
auntie. It was known to auntie.
It was not known to the auntie, and Judge Winnick actually found that testimony to be wholly incredible. There was, the auntie that is being talked about was the vice president of Beacon Residential.
Whose testimony did Judge Winnick hear? Just to,
Judge Winnick heard Ms. Pipkin's testimony at length throughout an all-day proceeding, and he heard the testimony of the person in the management office who interacted with Ms. Pipkin specifically on any basis during the time frame in question, from 2009 all the way through 2000.
is that the auntie person?
No.
Okay,
The auntie is the vice president of Beacon Residential.
okay.
There is no basis for those findings. Ms. Pipkin, a lot of the testimony, if you look at the record, a lot of the testimony was found absolutely not credible.
Let's try and figure that out if we could for a moment, though.
Yes.
And try and understand what the judge was permissibly able to find at this stage of the motion to intervene and what he's not permissibly able to find.
So
So
at the-
for instance, I'll give you just one example. You use as many as you want, but he says definitively, after listening, I find that the reason she couldn't get back on the lease had nothing to do with domestic violence. Can he do that at the motion to intervene, or is that, as Justice Budd was getting at, for later?
Well, I think that two things, because there is a two-prong inquiry there. Number one, he has to decide if she has the right to intervene on her own behalf. And when doing that, he has to decide, does she have the right to intervene? Does she have a possessory interest in this property? No, she has no possessory interest in this property. So we have to find one. We have to find one that's going to qualify her as either being an applicant, an occupant, or a lawful tenant. In order to do that, they invoke VAWA. And in hearing the testimony about whether or not VAWA allows her to have that occupancy right, the judge found no, because there's fraud. He then also, you are correct, Judge Lowry, that he also found later that she had committed fraud and therefore couldn't qualify on behalf of her children. But that was a separate inquiry when dealing with the second prong of the test. So basically, what he was saying was, even if we get to the fact that the children had some right, which I disagree with, but even if we get to that inquiry, she, as the legal guardian, not a new guardian, as always been the guardian of these children, doesn't otherwise qualify, again, because of the fraud. We're not making a determination on whether this tenancy should be terminated. We're making this determination to determine if she, in fact, has a right to intervene into this action as a party of interest.
Well, the problem, though, is Rule 24 does not say that the applicant has an interest relating to the property. It says when the applicant claims an interest relating to the property.
Right.
So isn't that sort of the core issue as to whether or not this determination is based on her claim or whether it is based on factual findings as to whether that claim indeed is true?
Right. And Judge Winnick made the decision, listened to all of her testimony.
I understand that, and let's assume that he's a perfectly reasonable fact finder. The question is, If intervention had been found, would this matter have been one decided potentially by a jury?
Potentially by a jury, correct.
So the real issue is this determination of whether or not she has an interest, one that should be decided by a judge at a motion to intervene, or should be decided by a jury after the intervention is allowed.
Right, and we have to play that to its logical conclusion, unfortunately. If every person who came in to a summary process action, who is not a tenant, who had no lawful right to be there, and could say, I claim that I have a right to intervene into the summary process action, the practical effect with that, we would have trespassers, we would have guests, overnight guests, we would allow people who were Airbnb visitors who could say, I have an interest in this property. I slept overnight in it a few times.
But she is claiming an interest based on a federal statute, which would not apply to an overnight guest or trespasser or any of those other examples that you cite.
Correct. She is claiming an interest pursuant to a federal statute that does not establish a possessory right. That federal statute protects in the event that she is a tenant, an applicant, or a lawful occupant, none of which it was found that she was.
Putting that aside, whether or not she fit the contours of our, what's your answer with respect to the children, whether or not the children have a right of, to intervene based on a VAWA application?
So the children don't have a right to intervene. It's a question of whether or not Ms. Pipkin would have a right to intervene on behalf of those children, because they are minors.
Right, and I get that, stated better.
And then the question would be, do they have an,
I would give them.
well, VAWA doesn't. I mean, VAWA, they need to have an independent right to occupancy in this apartment, an independent possessory right. They don't. Their right to occupy that apartment is expressly dependent on their caregiver. So it was dependent on Mr. Pipkin.
It doesn't matter how tenant is defined, so that they were also presumably on the lease?
So it was, they, in order for them to have been lawfully on the lease, they had to be there under a lawful tenant, and that was Mr. Pipkin.
Okay,
But now they are there and they're left.
but doesn't VAWA recognize them as tenants?
VAWA does not recognize them as tenants. VAWA recognizes them as occupants. They do not have an independent tenancy right in this apartment. VAWA does not make them have an independent tenancy right. It has to be dependent upon a person who has a lawful right in that apartment. And Mrs. Pipkins is trying to assert that for them.
Well, I'm looking at, the federal statutes are very long in their numbering. 42 U.S.C., section 14043, small e dash 11, paren A, denial of assistance, tenancy, and occupancy rights prohibited, which says no person may deny assistance, tenancy, or occupancy rights to housing assistance under a covered program to a tenant solely on the basis of criminal activity directly related to domestic violence, or if the tenant or an affiliated individual of the tenant is the victim or threatened victim of such domestic violence. So the claim, I gather, would be that children are affiliated individuals and they effectively are victims of the domestic violence.
Correct. So the children, they're distinguishing. The children are lawful occupants, but that lawful occupancy, does not make them an independent tenant to this relationship. There has to be, their tenancy, their occupancy is dependent upon another individual. And if that individual is Miss Pipkin, who has always had custody of them based on her own testimony, there's no new custody relationship.
So how does
then
that
she
right get
disqualifies.
protection? If you have a right of occupancy, how do you protect that? Are you saying that it's a right in name only if the mother can't come into court and protect their right to occupancy?
Right. If the mother disqualifies from her ability to be able to come in and protect that right, yes.
So
These are not abandoned children.
So what do you do in a situation, which may or may not be this situation, but I think happens? Abusive spouse or boyfriend does not want the wife or the girlfriend to be on the lease because he has greater control over her if she is not independently on the lease, so bars her from being on the lease so as to have more power over her, beats her, woman then goes to court and gets an order under 209A to stay away, and the father, who's the only person who's on the lease, then is barred. Landlord goes to evict. Children effectively are being evicted from that household as a result of the domestic violence. Do they have no protection under in your?
They would have protection if there was a qualified guardian who could step in to assist them in those occupancy rights. But those rights, occupancy rights, would have to be dependent on a qualified individual.
And would the
And
woman that I describe in my hypothetical, which again may not be this case, would she be a qualified guardian, even though she lived there but was not on the lease?
No. Ms. Pipkin?
No, I'm not referring to
Oh,
Ms.
I'm
Pipkin. I'm
sorry.
referring to a woman who, put aside the issue of fraud, she's not on the lease only because the boyfriend says, I don't want you on the lease because that would give you an independent right to be here. I want to have total control over you. I don't want your name on the lease. I'm sure that happens.
It does happen, yes.
What happens to the children when there's a stay-away order against the father and the landlord seeks to evict?
So in that scenario, the woman that you're describing would otherwise qualify. She's not there out of a fraudulent activity. She's there because of abuse. And that would be evaluated. And if she otherwise qualified for the property, like didn't make $5 million a year and passed the criminal background check, then she could stay. And that would be an option open to them under the VAWA protections.
And would that be a determination made at the motion to intervene stage or a decision made at the trial stage?
I think it would be an interest. The judge made a decision based on this stage because he found that she had no possessory rights because of the fraud she had committed. Let's not forget,
But I guess the issue
and this is
seems
not.
to be, whose decision is that? Is that the judge's fact-finding decision, or is the judge's fact-finding decision much more modest in a motion for, to intervene, and is that a decision for the jury to make?
I would say that the judge conducted extensive evidentiary hearings on this issue in making sure, in fact, proceedings were suspended so we could give the entire tenant file of Mr. Pipkin to Mrs. Pipkin and her lawyers to determine if there was anything in there that could in any way support that there was anything going on other than fraud. Ms. Pipkin admitted on the stand in her own testimony to the fraud. This was not something that the judge said, you know, I'm listening and it sounds like fraud. This was something that her own testimony documented the fraud that was being committed. She was mad that her husband left her for another man, and she was angry about that. There was also testimony that Mr. Pipkin got a restraining order and in 2013 against her. Do I think that this relationship broke down? Absolutely. But it broke down after they decided that for years they were not going to reveal the fact that Ms. Pipkin was living in this property, which would have resulted in a much higher rent. Ms. Pipkin also testified at the hearing that not only were they paying the lower rent because she was not there, she was hiding there, but because she had worked full-time for all of those years, from 2012, 2013, 2014, and 2015. She worked full-time. That was never factored in. This was an issue of them making a choice, and unfortunately, they have to live with that choice. They made a choice to defraud the housing situation here and to manipulate the waiting list.
Well, let's just assume all that for the purposes of my question.
Yes.
Assume that the judge listened to everything, exhaustive testimony, exhaustive findings, and that Ms. Pipkin actually said, well, yeah, I wasn't on the lease and I was living there anyway, all of that. Mm-hmm. So the finding that she's deceitfully not on the list, not on the lease, deceitfully not on the lease. Is that the end of the story with that finding as to the motion to intervene, even if the two kids are on the lease, or even if she's also an applicant quote-unquote, for the purpose of domestic violence.
It's the end of the story in relation to Ms. Pipkin's right to intervene on her own behalf. As far as those children go, we take another step, because those children would then have to, can we have a guardian? Do we have a guardian here? And Ms. Pipkin's always been the guardian, not a new guardian. She's always been the children's guardian. Does that guardian otherwise qualify for participation, for occupancy, for eligibility? And those findings of fraud, disqualify from all of that.
So that
And
means
that
the children are left unprotected.
The children are left to have to go with her to other housing, to get a different guardian step in, or to have to go with their father, who's now back in the area.
And so it depends on the behavior of the mother.
Correct.
As to how the
Because
children-
she's claiming to be their custodial guardian and always has been.
Yeah.
And unfortunately, she engaged in a course of conduct over a period of several years in which she defrauded this housing development and now is wanting to manipulate that process in order to jump the federal wait list.
Well, you do realize that we don't decide cases based on people's conduct. We decide the case based on the law. So
Correct.
I hear what you're saying. She maybe did a bad thing, but in the end, we have to decide this case on the law, not because we're put out by her conduct.
I do understand, but the clear,
Yeah,
whether or
but
not
you know,
the judge.
you keep saying it as if it is the end of the story, and I'm just trying to say that it isn't.
I agree. And I know the review is a question of law, but it's also how the judge applied those facts and whether or not he made clear error. And I am
Or
saying
whether
that,
he went too far for findings as to intervention only. That's all that was before him, was a motion to intervene. And he could have had 10 days of hearings, and if he made facts that went beyond the motion to intervene, that appropriately, as Justice Hines is pointing out, as a matter of law, then it really wouldn't make any difference how thorough his review was.
correct. I do think that he was careful to limit it to the intervention on behalf of Ms. Pipkin and then the intervention on behalf of Ms. Pipkin on behalf of her children. And that's seen in the transcripts.
Okay, thank you so much.
Thank you.
And we'll
Thank you.
take our morning break. We will